For a long time, opposition members of parliament have challenged the appointment of their fellows as ministers on ground that it compromises their ability to question government excuses and failures. The MPs have always urged that service delivery in most cases is inequitably distributed across the country when lawmakers who are appointed as ministers divert money and other materials to their constituencies to earn political capital. Today, lawyers Michael Aboneka and George Musisi have filed a petition in the Constitution Court challenging the appointment of members of parliament as ministers.
The overall function of parliament is legislation, oversight, appropriation, and to check the executive. So when a minister is also an MP, it's a fusion. When will you ever see a minister sit in a committee of parliament? Because we sent an MP to do oversight function.
According to the two lawyers, the appointment of MPs as ministers makes them fail to question poor service delivery because they are bound by the principle of collective responsibility in cabinet.
The Attorney General and Deputy Attorney General cannot be MPs because they become ministers and they are part of the executive. So there is no way you can have an Attorney General representing the people that voted for them on matters to which actually are contrary to their the ones that they're supposed to advise government on.
The petitioners also argue that serving as an MP and a minister comes with privileges for the two offices, which means that the occupant of the two offices is exorbitantly paid and remunerated.
Ministers receive a car as a minister, and then they also receive a car as an MP. They receive emoluments as an MP, and they receive emoluments and benefits as a minister. And that is wastage of public resources.
One of the roles of the Member of Parliament is to keep government in check for purposes of accountability, according to Musisi. He says the appointment of a Member of Parliament as a minister, as is the case today, creates conflict of interest.
If you look at the functions of a Member of Parliament, primarily is to keep government on check, the executive, for purposes of accountability. Even for legislation, you're supposed to be independent when you're legislating. Yet most of the legislations come from the executive. So yet if you look at the functions of a minister, a person who's been appointed a minister, primarily the loyalty is to the president.
They want the Constitution Court to declare the double appointment unconstitutional.
Court has already ordered that a serving judicial officer cannot be a part of the executive. The Constitutional Court has already ruled on that. So we want to see if a judge cannot serve in the executive, why should an MP serve in the executive?
We are seeking for orders that the Constitutional Court declares this unconstitutional, and if it's convinced by our arguments, we believe that it will stop the habit that as it is now for sitting members of parliament to act as ministers.
Becca Senyonga Mulinde, NTV Tonight.